Now, Sedina Tamakloe, abusia, ne appeal na wako wini ewa appeals court no, a divided opinions. In fact, and I'm catch you say NDC big wigs, they are not happy with the decision. Yeah, free appeals court eba you know. Then no free zero majority this. In fact, judges me say transfer ni now. Omo nyina really say let's acquit her and discharge her. What it means is that the woman now is a free woman. Kwa do the born ni nyina no. Ya hohuru ni nyina. Oni boni bia. Enti Sedina Tamakloe winning the case ewa appeals court. After the high court, a 10-year jail sentence. No? Now, abusia, former deputy attorney general also over 2 cases. Alfred Tuah-Yeboah also case number 2 here. At the end of appeals court, and a judgment they free appeals court abano. One no more because there was sufficient evidence. A chese, Mamino misappropriated funds to the tune of 90 million Ghana cedis. The Mamino dear. No, so was serving jail term. You better, Alfred Tuah-Yeboah. What is your opinion on this particular thing? It looks like people predicted. Some Mamino. About way about NDC need to know. Oh, I'm never ba. No, I'm chef Yasika Krebi. Na be was starting appeal process. No, na fi wa wini. And no album no. And I'm for complain. But they can catch you say NDC in penny for the crown. Most of them are not happy with this decision. Right here on Soka Tour Show. But you subscribe. We have bell notification icon. Turning on video. No drop your one. Feel free to leave your comment in the comment section. Or share link in for fro and you be a share. Little Flower Green Clean Solution Center. You go so you to yourself for some power and you repair open cleaning company on. I'm a mobile CSA prepare for honum. Church, bank, institution, man, or office one myself, friend, numbers no good skills, never by dying. A credit, never junior, but trade money you pull at the amount. Opia choir, you were just off your canna or back master, just a traffic light, no. Or try up at one set if I saw about the 1 2. I say, oh, pay one set ever kind. Sir, and so, and a vending natural backups about able 2 menstrual pains and the abdominal pains are sent in, but your ultimate way, a man, chahu, FDR approving, a man using in us with the one as a different numbers, no. Na kwajo de na also be di ho adanse yen ko den ko tie Alfred Tuah-Yeboah former deputy attorney general den tia oni appeals court ni enya adwen
the name trial ni sha ase na o ye deputy attorney general right
me bet so
oh ba bet
so abra na penka e ho ba bet so
okay
le do me na me wo
okay I mean sir o share grounds of appeal na the first one was the charge sheet was defective, and you would realize the Court of Appeal ABC or decision mainly on that first ground of appeal it was saying I mean a defective charge sheet and I said then
yo binia me that's it. Yes, Court of Appeal judgment nyamia do mesmo bi ahwemo. You are right, say omo can rely on defective charge sheet. But the big campaign say, I disagree with the Court of Appeal. They didn't do a good job. Judgment doesn't stand the test of any legal scrutiny. Now, but the match data American.
Okay.
In your lawyer media, lawyer media would see me. The MPO, for argument's sake, the charge is quite a defective one. And just what the Nipano Ujano. By the appellate court. May come Section 31 of the Courts Act. Check 31-2. Now said the Parliament in Maxwell trial said the Court of Appeal as any appellate court will be on the ground say charge sheet a defective. Provided say miscarriage of justice MIA and so evidence via any record Nipano before. So the Court of Appeal is faulted firstly by Section 31.
And it's your considered opinion, sir, when they establish a charge sheet defective, no? What should have been the decision? Sir, they order a trial de novo? And I said
coming there.
Okay.
I'm coming there.
Okay, that's fine.
So the first time I say that's a defective, no. Next phase, and say, oh, she say, a dance here a warm cracker, so no. A dance here is support to any other charge, as you have it now. And I am pushing your catch them and say, could what work as a charge a defective one. What you do is say you order trial de novo.
In the answer, BB as a for.
Exactly. Because Ebasana is on technical ground.
Yes.
So, because we are talking about 90 million Ghana cedis. And I can't want them. But I will say, cash sheet, defective. So that's the first point.
Okay.
Second point, na a dance here, court anymore, court to be any fast one, and a dance here, one could be so, like I said, judgment, edimuana, like I said, amen. Edi kind 500,000 Ghana cedis, I can't say, must look for the command, that institution, or Ashanti region, no. A dance here, the court, and they say, a microfinance company in such cash the cano. Almost say interest, was no moon to be here. Don't miss some more the check. Ebra Maslok, Mammy Tamakloe. Now send this class to be out for 3 years. Mamma Cassa Debbie, on a board chairman, no Cassa Debbie, me near cash. A dancing American to be near what dancing. Yes, I cash no bank, that institution, cano cash, at the bar and kind. But you'll be here, Mamma, no Kai. There's a filling station, Barcelona, filling station. There are dancing, Sahono Mushiano.
Okay.
And on this cano, a shannon. Then I'll choke crackers and a sackers cano. But the sackers cano, while found commerce lock accounts to be. It's a great dance, and judgment, and I say, I see a dance here anyhow. So that's the first dance here. Solid. Unless, could appear a patch and say, I can't dance there, my Jesus Christ. If I am a quarter any dance here. Solid a dance here. Number 2, a dance here, a one craft as well, she said, Mammy Tamakloe, a mra, a ja, a shake and tamanto. O Mampani Mahama Samre 2013-2014. A castle mining first time master for, na says cano, Umfankoma, get the 4 mano, and show me Omujum. First can similar wrong at almost 1.4 million Ghana cedis. Audits na, investigators, it shows say, can be a core man or no, close to 700,000+ Ghana cedis. Almost 600,000 or 700,000 there, can anchor money be a home. And we are dance here, report no at the court farm or so. Number 3, Maslow, say, sensitization program from a manner, from about 80,000 of them throughout the 10 regions, 10 regions organized. And on budget close to 1.8 million Ghana cedis. Mammy Tamakloe, eco region me and sape out of the 10. Yes, so called yes, score spending a pay within 1,300, meaning I maybe 13,000. 1,003. So we almost 1.7+ million Ghana cedis, and also of fire. Another one. We are financially interested for more clients maybe. Don't buy 246,000 Ghana cedis. 1 year when you can spend even 1 cedi out of the amount. 1 year program na nipani biya. Let's can pass and go back. Do you dance here a walk in Kratemu? And the last one. We almost talk has be 350. Yeah, the dance there by a car can in a cost pan $10 million. Now so we have $14.5 million. Yeah, a dance here and the sun in my now the same mama cranny say, I dance here the bay more do you know, mamma no you say on my court, I mean and say I deal with it and you know correct in it here. So on what basis would the court of a PC say a dance here in this same with me? A year mamma quite be making also opinion that can so when you know correct, Mrs. Scanner by the coha, the winning coha, then that is all 2 sides. Minister criminal prosecution, the state must prove his case beyond reasonable doubt.
Beyond reasonable doubt.
But on the side of the prosecution, I mean, I can tell you without any equivocation, make Kansas City said, the state prosecutors, it tells me the man we, the public servants, investigators, the kind of auditors, don't be there dancing or court. The other court to Ghana, like court of because a dance anywhere. Like I say, idea, maybe 2 months.
But lawyer, even before the whether the charge sheet was defective and also defective, no, on even the evidence, no, and the probative value according to evidence, no, the Court of Appeal in Omu conclusion page 92, 93, and 94. mintiming kind, and I'm only taking a cursory look. So I share conclusion almost say paragraph 120. It has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused, and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. The principle articulated by Viscount Stanky in Wilmington versus DPP, our law student, say, and unshaken sense is not a technical nicety of procedure. It is the constitutional expression of the presumption of innocence, and it is owed to every accused. 121, I'm going to say, the learned trial judge lost sight of this. Confronted with a charge sheet drawn mostly in negative terms, that the appellant had acted without authorization or without due process, she reasoned that because the prosecution had averred a negative, it fell to the appellant to prove the positive. That authorization, process, or justification in fact existed. With respect, that reasoning inverts the very principle it purports to apply. 122. The manner in which a prosecutor chooses to draft a particular offense cannot, of itself, relocate the burden of proving an ingredient of the crime. A negative averment, artfully or carelessly pleaded, is not an exception or proviso. It's not an exception, a proviso, or a statutory defense. It remains in substance an element the prosecution must establish, and the difficulty of proving a negative is the prosecution's difficulty to bear, not the accused to solve. I will go further to emphasize the principle that unless a statute plainly places the burden of proving a particular element of an offense upon the accused, she is under no obligation whatsoever to lead evidence in aid of a prosecution's case that has not yet reached the threshold the law demands of it. To require otherwise is to ask the accused to complete the prosecution's unfinished work and to convict her for declining the invitation as was done by the learned trial judge. The prosecution's evidence on a fair and unaided reading fell short of proof beyond reasonable doubt. The shortfall was not made good by any burden properly resting on the appellant, and the trial judge's misdirection on this fundamental point goes to the very root of a fair trial. For these reasons, therefore, I am satisfied that the conviction and sentencing on all the charges, including those manifestly defective charges, cannot stand. I would allow the appeal and set aside the appellant's conviction and sentencing on all count. In the way and a Justice Emmanuel Ankama, I'm not sure this lead opinion, no? One, the evidence he believes said you couldn't prove the case beyond reasonable doubt because that it was for you to prove and not for the appellant, no, to rather prove positive. When you crafted the charge sheet, no, in the negative. Okay, hold counsel.
What kind the judge misapprehended, misunderstood the import of the prosecution's case. With a great respect to the judge, his appreciation of the burden of proof, wrong. In criminal cases, the state or the prosecutor is supposed to criminal cases. They'll say, there are some courts, if you prove a case beyond reasonable doubt.
Yes.
Everybody knows. This is not something the judge should lecture anyone.
Yes.
Now, who we are, then the accused person will have to just raise doubt to show, say, the okay, no prove beyond reasonable doubt. Something that everybody knows. So, before what to me, it does not answer the question. The key question is, charge sheet the state prepare, you must get evidence to back the charge sheet required. The advance here was a state no the advance and by my minus crata now of sign say scan magic I just cash a free more. Nipo discabaya no back case or baby shana bachuna filling station and can manage this cano. Accounts on prepare and issue say one first can for two company with the accounts no. If the get up today. Before Kaina ministers come manager no before Kataswana. No, that is not how the law works. With all due respect, the trial judge, a very good analysis of the judgments. I mean, you can judgment now. The first one judgment now. To the extent say, or evaluate the evidence. No, Mamma, the question is the Caribbean lawyer no or consider it, including Mamma the statement of the police or consider it. So the judge, sad that is not the court of appeal is telling us if the accused stating proven case beyond reasonable doubt, the accused person can say, I will not speak, and then the court will acquit her. No. The court can say, if you have a case to answer and you do not answer, the court can go ahead to convict you. And before the court will say, so, case to answer, no, the court must be satisfied, say, there's evidence on record. So the greater respect to the court of appeal, they grossly erred. Even almost talk about a charge sheet, say defective. Okay, we're not reading here now.
Yes.
That some are defective. And so what? Section 31 is clear. Section 31 of the Courts Act is very clear. Section 406, subsection 1 of Act 30 is very clear. The Court of Appeal got it wrong. The trial judge got it right. But Court of Appeal has 3 judges against 1 judge. The Supreme Court will have to step in to see, because this particular judgment, so muka sa dance woman no any dance meet the threshold and so what we call that friend yankopon na yankomedia dance ma. We are no magicians, but every single ingredient there can be no state in terms of the catching of the chances they will be in the negative or positive. Whether negative or positive, the state must prove its case. So it doesn't matter the language. You are supposed to lead evidence which will say there will cannot. We never said the same. I'm proving innocence. The Court of Appeal, they should also know that. You also know. Then no, the state never says to them, "Mama should come and prove her innocence." That's why the trial judge evaluated too. I mean, if you look at the Court of Appeal at the abonnent page, go to a trial judge judgment, not a 94-page judgment, and then look at the analysis for making it against the Court of Appeal judgment. To me, plenty English. But Ghana for Isika over 90 million Ghana cedis. And a Court of Appeal, if it's technical grounds, because then we can be Simon. Empo, the charge sheet is defective. A court doing substantial justice, and a court minded say also a protecting state resources. Say, I'm deciding you go back so that the matter can be tried again by the court.
In the then no on acquittal or better discharge. Yes.
Because that's on 30. So meaning if Court Act and I look at the Court Act, how would you put and in the
maybe section 31 of the Court Act.
Yes.
Appeal in criminal matters allowed on substantial miscarriage of justice. I don't know subhead there, no. Also 31-2, right?
Yeah.
31-2, good. 2, they say the court shall dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, or that the point raised in the appeal consists of a technicality or procedural error or a defect in the charge or indictment, but that there is evidence to support the offense alleged in the statement of offense, in the charge or indictment or any other offense of which the accused could have been convicted upon that charge or indictment.
Okay, you the whole plane. So Court of Appeal telling us this section no and I mean yes, was section 406 of Act 30 so 4061 with me here also.
Okay.
So as a lawyer, speaking as a lawyer, I can say the Court of Appeal has done a great disservice to the people of Ghana in this particular matter. They seriously erred. Our judgment cannot stand the test of legal scrutiny, a combination of whatever the judges think should be the case, but looking at the evidence on record properly so-called, the trial judge, the judgment, and also Ghana for I will be speaking as a politician, as a party in that case. I rather urge people who need that kind of thing. They should take the judgment of the trial judge. No more Court of Appeal, no more law no mo nke court of appeal for the omo ye no support I'm ready to support so man.
And to the former Deputy Attorney General Alfred Tuah-Yeboah and I'm in car right here on Sokatoa Show. Ecosystem program so as 94.7 from one million OB a bank comma another in 7 the program let's see actually again or this particular one media because the government must pay attention to optics. But how do you manage optics? Very, very important. Perception. Anyway, yeah, the program let's see. Bacho subscribe and start wakawati. Bacho comment no. Jago comment section mami. Enti you can kana for and you be ati. You understand what the jump. Bye bye.